John Finnis. Welcome to Jurisprudence, Lesson 40. My focus is to bring to you the thoughts about law by Professor John Finnis, an Australian born in 1940 and one who has taught law and has read law at the Faculty of Law of Oxford and taught law also at the Law School of Notre Dame. Professor Finnis does not require any introduction. He has also widely made huge contribution in his thinking in the American legal reality, in which he taught and he also shared his desire to adapt natural law theory and to bring it to the limelight of our contemporary understanding of the state law, and why he believes that law should have so much to do with the morality. Professor Finnis begins with the following premise. How do we make moral decisions? With this question, we are trying to engage ourselves with the thoughts of Finnis on the authority of law, also on the issues dealing with the external and the internal law, his distinction between the two, but most importantly, his attempt to give multifaceted definition of what is the law according to him. In his publication of 1980, known as Natural Law and Natural Rights, to which I invite you to read, it is very important for law researchers, but also practitioners and law students alike. In his definition, Professor Finnis looks at law as follows. His definition of law as an institution of rules. Rules made from regulative legal rules that are made from an authority that is standardly constituted and legitimate. He also seeks to do a similar definition of the natural law. Natural law, quote, is a set of principles of reasonableness in ordering human life in this community. Already we have detected something very unique in this definition. It is first, multifaceted. Second, he engages the understanding of law with the concept of reason. When we talk of reason, we recall the conversation around the natural law theory. He does not dismiss or leave out the thoughts of Plato, Aristotle, St. Thomas Aquinas, as well as St. Augustine, and those who developed the classic natural theory of law in the early days, the early times. But what is his new contribution? We are going to get there. But before we get there, Professor Finnis, in his definition that is very much supported, we can read through his theory the reality of the law in our legal system, especially in Kenya. Kenya has got a robust legal system with the sources of law, including the Constitution, the Acts of Parliament, the international law, and also the common law, case law, as well as the African customary law. Kenya has got robust institutions public institutions and private institutions, which are charged and mandated by, first, the Constitution of the Republic of Kenya, to serve the people of Kenya. And serving the people of Kenya is also mindful of the principles that are well indicated under Article 10 of the Constitution that deals with the principles of governance and the national values. Such principles as public participation, good governance, democracy, the rule of law, for instance, as well as the inclusivity, social inclusivity, as well as equality. The Constitution, the dedication of the Bill of Rights to the whole chapter 4 is so much telling when it comes to the desires of which the Kenyan people are expecting the law to serve them. This is as well read together with chapter 6, that is the chapter dedicated to leadership and integrity. There is so much to do with ethics and morality in the Constitution of 2010, and Kenya is not far from admitting what Professor Finnis regards as the common good, and people ought to act according to the basic goods and the principles that he underlines in his understanding of the practical reasoning. As a legal philosopher, Finnis is very articulate when it comes to this definition of law, but also when it comes to the understanding of reasonableness in ordering human life in the community, understanding of the sense attached to the meaning of law, but most importantly, the purpose of law. Law is serving a moral purpose in the community of humans in which reason plays a significant role. Reason is a practical reason he's referring to in terms of our actions, in terms of how people make moral decisions and moral choices. But this is also to be understood within the information behind it, that not every human being can or is reasoning in the same way. This is also well taken care of, because some people suffer from mental disorders or impairment of some kind, or a certain situation or circumstances that may again compromise their moral choices. But in this disregard, Finnis is concentrating his attention to tonic understanding of reason. Human beings are distinguished from other beings by the fact that human beings can reason. And in that case, reason becomes a fundamental and key principle on which the legal philosophy and the jurisprudence by Finnis is predicated. Reasonableness, again, we are referring to such issues that distinguish what we call the external and the internal law, according to Finnis, in which the external law includes the state law, the state enforced laws, such as the Constitution, as well as the entire body of the corpus juris known as statutory law, including as well the embodiment of the case law and other laws that are written. However, still, the internal law of which John Finnis is elaborating, we are concerned with the moral philosophy of law, in which the law must also be understood within one person's self, in the sense of introspection of an individual as a reasoning individual, And reasoning here means that the actions people commit themselves into must be also accompanied by moral choices, decisions made backed by moral decision, such as what is good and what is bad, what is wrong and what is evil versus what is good and worthy. What is good and worthy is what Finnis is referring to as the basic goods. But besides the basic goods, there's also the common good. The common good is that good of the community. Law is also sensitive to the value system, the standards, the ideals that people attach to the common good. The common good here is not only about what is public and what is private, because what is public may not as well satisfy the needs of the common good as a requirement. It is from this perspective that Finnis is enabling us to understand the significance of law, the role of law in our moral dimension in which law is understood as an institution. It is, of course, an institution, also looking at the way we classify law as public law and as private law and as commercial law, for instance, and as international law. All these categorizations are institutions in themselves. They are institutions because within the embodiment of the public law, for instance, we find the constitutional law, the administrative law, as well as the criminal law. But if we look at the entire body of the private law, then we find the contract law and all the statutory law that we find within our jurisdiction. Commercial law, the same. This categorization makes commercial law an institution of itself, the private law an institution, as well as public law being an institution. Another good example is the family law. It is an institution because within the family law, we get law of marriage, we get succession, we get divorce, we get so many other laws within it, such as matrimonial property law, women law, and many other things, FGM, and Sexual Offences Act, and many. Given this from his perspective, his contribution as a new concept in the knowledge is the law as an institution. And if it is understood this way, and it is embedded within the ethics of law or the morals of law, then we can see through the lenses of the theory of Professor John Finnis, now emeritus since 2010, speaking directly to us today, not to the olden days. He's not referring to the classic natural law theory as a rule by the hands of the dead, but is referring to the natural law theory as actually a theory that is making meaning even to our modern time. As much as we regard our legal system as very functional and effective, we need also to admit that within it, still we question the delivery of justice, whether there is access to justice for all, whether it is genuine for political leadership to mishandle the public or to treat the public with maybe some conversations that may not be ethical or may not be reasonable. In this case, we still question the reasonableness of the justice system, the reasonableness of those who offer legal services, including the advocates, our institutions, what has happened to them, Law Society of Kenya, and other big institutions that are expected to be the role models and to provide the much needed ethics when it comes to the administration of justice and how law is supposed to be understood. Still, we cannot dismiss the natural law theory, and we cannot neither dismiss its supporters. The common good of which Finnis is educating us has also been a subject of scrutiny by Bishop Augustine of Hippo, known as St. Augustine, in his Confessions. Read his Confessions. When Augustine talks about the two cities, the city of God versus the city of man, in which he sees the city of God being superior, that ideal world in which justice is found, and the summum bonum, that is the absolute good, is only in the city of God, but not in the city of man. The city of man in Augustine's Confessions is full of wicked men and women, full of sinners, evil, and justice cannot be expected in such city. But Finnis is not really buying into this Augustinian thinking, but he is looking at the common good as founded within the human community and the natural law, that is the reasoning, power of reasoning, and the way the law is that of the right actions, seen in the light of reason, but also in accordance with nature. In that understanding of St. Thomas Aquinas, Finnis is seeking to enable us today to engage appropriately with the practical reasoning, in which in the practical reasoning we see his ethics of law, the action of man, how people should act. People ought to act or should act in accordance with the common good, in accordance with the basic goods, but also in accordance with respect to other humans. People make moral decisions, moral choices, backed by moral principles. People choose to do the good, to do good for themselves, but also do good for others. People also serve the community, what we refer to in Kenya generally as giving back to the community. There is nowhere I've read other than this book and the writing of Professor John Finnis that sees that embeddedness, that involvement of law in the reality of the community and making human life better than what it is. So law has got a role and a purpose to drive the human community towards the achievement of its ideals, goals, values, and standards. This is all about John Finnis. The book is bulky, but if you read it through, especially page 273, where he puts clearly the definition of law, then you'll find exactly what Professor John Finnis is referring to. Thank you for being here. Thank you for watching. And also, thank you for the subscriptions and contributions. I want to appreciate you viewers. Thank you and bye.